All right, buckle up. We're diving straight into a courtroom tug-of-war over a plea deal in an OWI case. And if you think this is going to be straightforward, think again. The judge is about to throw a legal curveball that could derail everything.
Counsel, so I did go over this with my probation department, and we cannot take no contest, please, on OWI. So I don't know if you had, or for purposes of treatment court. So I don't know if you had a chance to discuss it with your client.
No, Your Honor, we were waiting. We were waiting to hear regarding whether the court could accept it. I mean, we did try to go forward last time in terms of supplying the court with a factual basis, but unfortunately, I think with the most central key.
Quick legal note, a no contest plea means you're not admitting guilt, but you're not fighting the charges either. In some cases, like OWI, the court may not accept it because it sidesteps the factual admission they need for sentencing. This is exactly the roadblock we're watching unfold.
Question, due to the medical episode my client experienced, she's not able to state it in the form or fashion that the court typically so requires. That was in part the basis of the no contest request. However, I do understand the court's considerations or requirements, I suppose.
Okay. So, do you need to speak with the prosecutor again about an alternate plea?
Your Honor, would the court be able to accept a stipulation to the report in this case for purposes of a factual basis?
With a guilty plea?
Yes, we did discuss that. Ms. Farms did indicate on the record last time she understanding that she could not plead no contest, would plead guilty. However, I think it was during the line of questioning voir dire for factual basis that the court then wanted to inquire further into this situation. So perhaps for purposes for the court's acceptance of the plea, by way of factual basis, we could stipulate to the report.
Okay. And ma'am, you went over your constitutional rights with your attorney, correct?
Yes.
And we went over them last time you were here as well. You understand you'd be waiving those trial rights if you entered a plea.
Notice how methodically the judge is going over her rights. This is called a plea colloquy. It's the court's safety net to make sure the defendant fully understands what they're giving up before pleading guilty. Miss one of these questions, and the whole plea can fall apart.
Yes.
There'd be no trial of any kind. You understand if you're on probation or parole and you enter a plea, it could be a violation of your conditions.
Yes.
And you understand if you're not a citizen of the United States and you enter a plea, it could result in immigration consequences up to deportation.
Yes.
All right. And ma'am, how do you plead to the charge of, was it an count one, OWI, or BH, wait, dismiss count one, plea to OWI. How do you plead to operating while intoxicated?
Uh-oh, here comes the critical moment. The defendant has a blood alcohol level of 0.204. That's over twice the legal limit, but she says she doesn't know if she drank. That's a problem. Without her admitting to drinking, the judge can't legally accept the guilty plea.
Guilty.
Has anyone forced you to get you to plea?
No.
Has anyone promised you anything other than the plea agreement to get you to plea?
No.
Are you pleading guilty because of your own free will?
Yes.
Okay, ma'am, were you?
And there it is, plea rejected. This isn't just stubbornness. The law requires a clear factual basis. No admission. No guilty plea. This means the defense now has to head back to the prosecutor and renegotiate or go to trial. What would you do if you were her attorney?
Operating a motor vehicle in the city of Taylor on March 26th of 2024?
Yes.
And while you were operating that motor vehicle or before, had you had something to drink?
Not in my right mind, no.
Yeah.
I mean, I'm not, if she had a .204, if she can't tell me she at least drank alcohol Mr. Goldman, I'm not accepting the plea. And it's not, I mean, if Miss Farms doesn't know if at a 0.20, if she had anything to drink before she operated that motor vehicle, I mean, I can't take a plea on that. I mean, if she can't at least acknowledge that she drank, and if she doesn't at least have knowledge of that, I mean, then it's a straight no contest plea, and you have to go back to the prosecutor and see if they're going to make the same offer. I mean, if she can't tell me she was operating a car on that day in the city, I mean, I can't get anywhere with her.
Your Honor.
Can I get Mr. Waringa in here?